morning. I am waiting for our speakers to join. We'll start at 10 o'clock. Thank you.
Hello.
Good morning, colleagues. We're going to start in 2 minutes. Apologies for that. I'm waiting for our first speaker to log in. Okay, all our presenters are here. Colleagues, before we start, can you hear my voice? Is your sound okay? Can I see the thumbs up because you are muted? Okay. Thank you so much. Welcome to today's webinar. And thank you for taking the time to join us again. And those who are joining for the first time, thank you so much for joining. We are required to educate and inform both consumers and practitioners in respect of Section 69. And what we are doing today, colleagues, is legislated. My name is Naledi. I come from the marketing and communications. And today we're going to focus on the two topics of avoiding rental disputes. And another topic we're going to touch on is understanding the PPRA claims process. We encourage everyone to participate. It's going to be a friendly discussion, but we will take the questions later on. We have our speaker coming from PPRA. His name is Mr. Khwadi Mpiepa. He is the founding director of Mpiepa Attorneys, a boutique legal practice based in Midrand that specializes in employment and labor law. He's an admitted attorney with 20 years experience. Mr. Mpiepa completed the Management Advancement Program at the University of Wits Business School. He holds a postgraduate certificate in law from the School of Legal Practice, and he also obtained his Bachelor of Law from the University of the North. He started here at the PPRA as a legal officer with the investigations, mediation, and adjudications department. And now he's working currently and serving as a claims manager under enforcement and compliance. He is not alone. He will be joined by our second speaker, coming from the rental tribunal, Ms. Lingau. Currently, she is serving as the acting head of gender equality and anti-discrimination at the University of the Free State Bloemfontein campus, where she leads initiatives that promote equality, human rights, and the prevention of discrimination, gender-based violence. Ms. Geraldine Lingau is also, she's serving as a Deputy Secretary General of the National Community of Practice for Gender Practitioners in South African universities, contributing to national efforts aimed at preventing gender-based violence. So this is one of the topic and one of the work that she's passionate about, in promoting gender equity across the higher education sector. And Ms. Lingau holds a Bachelor of Commerce in Law, an LLB, and a master's degree in gender studies from the University of Free State. She's an admitted attorney of the High Court, a qualified mediator affiliated with the Free State House of Mediators, an associate at Pedezia Pion Attorneys, and a director of the Mwepa Tusi nonprofit organization. Before we begin, please take note of the following housekeeping rules. Those who attended before, you already know this by now, that you are muted. And throughout the presentation, we're going to allow the two presentations. If you experience any difficulties, I urge you to log out and log in again. And all the questions, you can start posing your questions now on the Q&A and the chat function, and we will address them immediately after the two speakers have presented. We will address, as many questions as we can up until 2 o'clock before they go to their next meetings. The webinar is recorded for referencing and education purposes. We're going to put it on the YouTube PPRA TV. Please follow us on that channel if you don't follow us, so that you can also access the previous webinars we've posted before. And the presentation, I know I'm going to get the chats saying, can you share the slides? Yes. Presentation material will be shared after the presentation with everyone who's in attendance. I'm not going to waste any more time. I'm going to allow Mr. Kwadi Mpiepia to take us through the presentation. You can flag, I'm going to stop sharing the handles, and you may flag your presentation. Put it on slide mode, please, and you can take us through. Thank you.
Thank you very much. Good morning, everyone. As said, my name is Khwadim Pepsa. Are you able to hear my voice?
Yes.
Thank you very much. Are you able to see the slide?
Not yet.
Not yet. Okay. Are you able to see now?
It's not loading. Did you click the share, and because you must open it first and click share and then click on the slide. But if there's a technical challenge, I can flag for you the site. Just let me know if you need help.
I think I did this side.
It's not showing on my side.
Sorry.
Would you like me to share for you?
Yes.
Okay. Okay, colleagues, I won't be able to see your chats, your questions. I won't answer you now. I will answer you after the presentations because I'm flagging for our first speaker. But before I put it on slide mode, can you see the presentation? Colleagues, can we see thumbs up? Okay, we have thumbs up. The hands, we will deal with them after. Mr. Mkyepa, can you see the slides on your side? They are on slide mode.
Let me see. I can see the slide.
Okay.
Okay, thank you very much, ladies and gentlemen. My name is Khwadi Mpepsa. I am the claims manager. I'm going to make a presentation about the claims process at the Property Practitioners Regulatory Authority. Ladies and gentlemen, I'm going to start with the old act, the Estate Agency Affairs Act, and then later on I'll deal with the Property Practitioners Act. The reason for us in doing this is we all know that in February 2022, there was a repeal of the Estate Agency Affairs Act, and the Property Practitioners Act came into effect. So as the Property Practitioners Regulatory Body, we still have claims that we received in terms of the Estate Agency Affairs Act, and we are now receiving claims in terms of the new act, which is the Property Practitioners Act, that came into effect on the 1st of February 2022. Claims in terms of the Estate Agency Affairs Act 112 of 1976 is regulated by Section 18 and Section 19 of the Act. It is important for me as an introduction to indicate to you that it will be very much important and easy for you to understand if I were to deal with these provisions so that it becomes clearer. And then as we go on to the new act, which is the Property Practitioners Act, you will then identify the differences between the two acts because there are some differences. Section 18 of the Property Practitioners Act, it tells us that the Estate Agency Affairs Board Fund, the Fidelity Fund, it's liable to pay claims where money has been stolen or misappropriated or lost due to the fact that the estate agents has stolen that money or has failed to comply with the provisions of Section 32 that is failure to deposit money into the trust account or failure to retain money in the trust account until you are lawfully entitled to it or you are instructed to make payment therefrom. So this misappropriation or the failure, it must be done by an estate agent. And the agent must be doing so in the course of his business as an estate agent. I'll tell you why we are saying that as we go on. The money so deposited or so paid to the estate agent. The person who is paying that money will call them or label them the claimants. The agent must be in possession of that money on behalf of the claimant. For example, let me give a simple example. The rental deposit. The tenant applies to occupy a property and is required to pay a rental deposit before he occupies the property. He pays the rental deposit to the agent. Now the agent must deposit that money in the trust account, or if so instructed, invest that money on behalf of the tenant until the end of the lease contract. At the end of the lease contract, then the agent will look as to whether there were any damages that they have to deduct from the deposit. If there is none, the money belongs to the tenant, together with the interest earned during that particular period of time. The fund is not liable to pay any damages. So the claimants cannot come and say, I have suffered damages as a result of, and therefore you have to pay me for damages. That's not what the fund is meant for. Importantly, and I want you people to know this, if you look at section 18, subsection 3, it tells us that no person shall have any claim against the board in respect of theft or failure referred to in subsection 1 unless the claimant has within 3 months after he became aware of such theft or failure by the exercise of a reasonable care should have become aware of such theft or failure, given notice in writing to the board of such a claim. So in other words, what the claimant is required to do is, within 3 months of becoming aware that the agent has misappropriated the money or failed to pay the money to the trust account, notify the Estate Agency Affairs Board. And if you fail to do that, this section is telling us that the fund is not going to be liable. Do you understand that? However, as we go down, there is a provision that tells us that despite that the 3 months period may have been not complied with, the board has a discretion to exercise as to whether it should entertain the claim despite that the 3 months notice has not been given. I'll give one example in a matter that we gave, and I know this normally happens. So in circumstances wherein you'll find that the claimant is late. In the case that we did recently, the claimant was the landlord in that the tenant rented the property, and before the end of the lease agreement, the landlord passed away. So we all know what happens after the death of one of the of a person. There will be administration of the estate. Executor was appointed. It's a long process that the master's office has to issue the letters of executorship. And as a result of that, the executor was delayed in notifying the board. In his claim, the executor explained in detail what happened, leading him to the delay in not filing this notice in terms of section 18, subsection 3. And in that matter, the board exercised the discretion, looked into the matter in totality and say, under the circumstances, we condone the non-notification of 3 months. And the board considered that claim, and the claim was accordingly settled. Section 18.3b tells us that the claimant has within 6 months after a written demand was sent to him by the board, furnished to the board such proof as the board may reasonably require. Now, this is important. This is after you have lodged a claim and you get a notice from the Estate Agency Affairs Board to say, please furnish us with maybe the proof of the rental deposit. So this section is telling us that then you have a period of 6 months within which to furnish that. If this period elapses, it will be considered that you failed to provide the document and your matter will then be closed. However, the very same discretion that the board can exercise in terms of section 1838, the board may exercise under these conditions. It will depend on your reasons as to why. But importantly, it is very much important that you timeously furnish the estate agency affairs board with the required proof in order for the claim to be assessed. As I've indicated, proper proof is furnished. The claims officers will require you to provide them with the documentation which are required in order for the claim to be assessed. And somebody once asked me, how do I lodge a claim with the estate agency affairs board? I said the first step for you is to lodge a complaint form with the legal department. On the receipt of your complaint, the legal department via the legal officer will assess as to whether there is a potential claim against the fund. If the officer is of that view, then the officer will prepare an internal memo from the legal department to the claims department to say there is a potential claim against the fund and attach the complaint together with the supporting documents that the complainant would have furnished to the legal department. Then on receipt of that, the claim secretary will then do the internal processes of processing the claim, allocating a reference number, a claims reference number, and allocate the matter to the claims officer. Then the claims officer will look into the matter and write you a letter acknowledging receipt of the potential claim and send you the claims form and request you to complete that in full and require you to submit any documents that they may require. Let's move to the next slide, which deals with the nature of the claims that we receive in terms of the estate agency affairs board. We categorize them into two. We have what we call the ordinary claims, which are your deposit or rental on not paid over, agents absconds, trust money no longer in the trust account, or the claimant sued an agent or the principal and executed on his judgment now claims there is a shortfall in that particular judgment. Now, what happens there, if I were to simply explain it to you, these are the ordinary claims that we receive. Normally, you'll find that a deposit has been paid to the agent at the end of the lease. When the tenant is saying, where's my deposit? The agent decides not to pay back the money, or the money is no longer in the trust account, it has been misappropriated. So such a claim will be investigated, and the agent will be afforded an opportunity to respond to that claim, to tell us what happened to the money. Most of the time, the agents are not doing that. And I can tell you, property practitioners, this is where the problem starts. Because firstly, if you don't respond, what we are going to do as the claims department, we are going to consider this claim based on what the claimant is saying. And if the claimant meets the requirements for the claim to be paid, we'll pay the claim and we are going to block you. Firstly, because you failed to respond and that we settled money that you allegedly misappropriated. Then you'll try to apply for a fidelity fund certificate. You will be told that you have been blocked and therefore an FFC can be issued for you. So you'll have to come through me. I'll have to go into the system. You will need to pay that money back to the fund in full before you can be issued with a fidelity fund certificate. The other types of claims is what we call the extraordinary claims. Mostly is where the curators are being appointed. And a simple example that I can give is where a managing agent has misappropriated money of different body corporates. And for, let's say, for example, Mr. X from whatever law firm has been appointed as the curator, and he brings to our attention the claims, the potential claims against the Estate Agency Affairs Board Fund, Fidelity Fund, and he says the following body corporates have claims, and they submit documents in regard to those claims. So that's one of the matters that we call the extraordinary claims against the fund. You'll find that there are different entities that are claiming against the fund. A lot of money has been misappropriated, or the what we call the liquidator appointed. You will find that an estate agency is owing a certain company and they've been legally liquidated, finally liquidated, and a liquidator has been appointed. What is important I want you to know this. If your business gets liquidated, that has nothing to do with the money that is in the trust. Trust money does not belong to your business, and the Estate Agency Affairs Board, or currently the PPRA, must be immediately notified when somebody is getting liquidated, so that we can have access to that trust money and accordingly deal with the issues together with the liquidator to ensure that each and every person who has paid money in the trust account gets his money back, together with the interest for those who invested the money. Or there is a litigation pending. It's a claim, but there is a litigation pending in court. In such circumstances, normally we will await the outcome of the court. Not that we will say we are not paying the claim. The court may decide and make an order and to say, the agent, you need to pay this much, and the sheriff goes, attaches property, but to find that the claim has not been satisfied. So our fund will be liable to pay the balance thereof to those claimants. Lastly, the multiple claims, the body corporates requiring prolix documentation. I think I've touched on this aspect. Now, I'm going to deal with the claims process in terms of the Estate Agency Affairs Act. A claim lodged online using the complaint procedure. This is what I explained to say what is required for the claimants. The first thing to do is to complete the complaint form, attach the supporting documents, and send it to legal@eab.co.za. I think it's legal at the ppra.org.za currently. Then that complaint goes to the legal department. It is through the legal department that after the legal officer has assessed your claim, your complaint, will say there is a potential claim against the fund. Then the legal officer will escalate that matter to the claims department. Then on receipt of the claim as the claims department, we are going to investigate, we are going to require proof of a valid claim. For example, if it's a lease agreement, if it's a lease, we will require a lease agreement. We will require the proof of payments of the rental deposit, the proof of payments of the rentals, the correspondence between the agent and the tenants and the landlords in respect of that particular lease. And once all these documents are collated together, the claims are being presented to the claims committee of the board. The committee will then assess the claim and say, yes, there is a valid claim against the board, and it will make a decision whether to approve or to repudiate that claim, looking into what happened. And it may make an order on the money deposited, the interest, and the costs in terms of the Estate Agency Affairs Board. I want you to know this. On the quantum, on the interest, and on the costs. When I deal with the Property Practitioners Act, there will be a difference on this aspect. Hence, I said, let me deal with the old act first, and I'll go to the new one. And then these claims are being paid by the finance department, obviously, of the Estate Agency Affairs Board from the Fidelity Fund. The challenges which were faced in respect of claims in terms of the Estate Agency Affairs Board is that, one, the fund was paying out of actions of unregistered agents. So in terms of the Estate Agency Affairs Act, it was immaterial whether an estate agent has a fidelity fund certificate or not. Whether he has or not, it was not a requirement that he must be in possession of a fidelity fund certificate. Then the fidelity fund will be liable as long as that person who misappropriated the money is an estate agent and he was doing that within the course of his business. The claims were uncapped. So it didn't matter. If for example, the agent misappropriated 100 million, the fund will be liable to pay 100 million. However, with the Property Practitioners Act, it's different. I'll talk to that and I'll remind you what the difference is between the two. The board has inadequate statutory powers to safeguard trust funds. It had no powers to obtain trust account statements or to close trust accounts, seize trust monies without a court order. So the board will require a court order in order for it to obtain the trust account statements or the trust accounts, to close the trust accounts or to seize money that is in the trust account. So the Estate Agency Affairs Board was required in terms of the law to first go and obtain an order of the court in order to get that. It was established that the banks and the South African police services were uncooperative. I'll tell you why we were saying this. You will find that an agent has misappropriated money. The complainant goes there and open a case for theft. Money has been stolen from the trust account, the money that belongs to the complainant or the claimant. And when the claimants arrive at the police stations, they're being told, no, this is a civil matter between you and the agent. We have nothing to do with it, which is legally wrong. And I'm so happy that my seniors have addressed this issue with senior members of SAPS and the National Prosecuting Authority, because that is wrong. And it was very important that SAPS trains their members in respect of this aspect. Another challenge that we were facing is that the court process, as we all know, it takes longer, is slow. And the last aspect, we'll find that the claimants, more particularly the body corporates, will find that they do not have access to documents required to prove that claims. And then this makes a challenge, because then if the documents are not there to prove that claim, it will mean that the claim will be repudiated. I'm now going to deal with the current act. And I think this is of interest to everyone. You all want to know what is the status quo in respect of claims against the Property Practitioners Regulatory Authority Fidelity Fund. I approached this aspect in this manner. The important sections is section 35 to 44 of the Property Practitioners Act 22 of 2019. This section, I quoted that, and it is very important for me to read this thing and then thereafter to elaborate on it so that you understand where we are coming from. Section 35 provides that the fund must be maintained and applied to reimburse persons who suffered pecuniary loss by reason of 1, theft of trust money by a property practitioner who was in possession of a valid fidelity fund certificate at the time of the theft. There is an important aspect that you need to know, is that currently, in order for the claimant to be successful, he must prove that the property practitioner that misappropriated the money was in possession of a valid fidelity fund certificate at the time of theft. So in other words, it is important for members of the public, before they entrust property practitioners with their monies, to inquire with the Property Practitioners Regulatory Authority as to whether the particular estate agents or a property practitioner have been issued with valid fidelity fund certificate. And if they are not doing so, they run the risk of their claim in future being repudiated for the fact that they were not in possession of a valid fidelity fund certificate. 2, the failure of a property practitioner to open and keep a trust account with a bank that is duly registered in terms of the Banks Act, and I said in terms of the law, or to retain that trust money so deposited in terms of subsection 1 or invested in terms of subsection 2 until he or she or it, one, is lawfully entitled to such money or is lawfully instructed in writing, importantly, in writing, to make payment therefrom to any person. Now, for you to claim that I've been instructed to make this payment, you must produce a document that is coming from the claimant or the person who deposited the money, instructing you to make that payment. So it is no longer a defense to come to us and say, but the tenant verbally gave me instructions to pay this money. It's not a defense. The law requires that that instruction must be in writing. We then move further to section 30. On section 35, there is an important note for you to have a look at. If you look at section 35, subsection 2, it tells us that no person has a claim against the authority as contemplated in subsection 1 unless the claimant has, one, importantly, the claimant has given notice to the authority of a claim within 3 years after the circumstances giving rise to a claim. Now, the period now, remember in terms of the old act, I said 3 months, you must give a notice. In terms of the current act, that notice must be given within 3 years and not 3 months. That's the difference between the two. And if you fail to do so within 3 years, the unfortunate part is there is what is called the Prescription Act. So your claim will prescribe in law, and the fund will raise that as a defense and repudiate your claim. Secondly, the claimant has furnished the authority with the required proof within a period of 3 years after a written request was sent to the claimant by the authority. Now, what is important is when the claims officer sent you a notice to say, please provide us with this proof provide us with the proof of payment or this document. The law says you have 3 years within which to do that. In other words, my understanding is to say, by lodging the claim with us, you interrupted prescription. Now prescription is going to run from the date you receive the notice until you furnish us with the required document. That must be done within 3 years. And if the 3 years elapses, that claim is going to prescribe. And we'll raise that as a defense and repudiate your claim. Now, what is the process to be followed in order to lodge a claim against the Property Practitioners Regulatory Authority? The claims are also lodged online using the complaint procedure. The legal department, we call it the IMA department now, is the Investigation, Mediation, and Adjudication Department. For us, the complainants which incorporate a memo for a possible claim against the fund to the claims department. So you will lodge your complaint, the complaint form, your section 28 form, with the legal department. The legal department will then do their process, allocate it to the legal officer who will assess and say there is a potential claim against the fund, and then forwards it to the legal department with a memo to say there is a possible claim against the fund. Then the claims department, through its secretary, will register the claim, allocate a claims reference, and allocate that to a claims officer. The claims officers are our investigators in the claims department. Then the claims officer will send out an acknowledgement letter together with the claim form to be completed by the claimant. Now, remember, you completed the complaint form initially. Now, you receive an email or a correspondence from the claims department to say, we acknowledge receipt of your complaint and a potential claim against the fund. Kindly find attached here to a claim form for your completion in full and attach the supporting required documents. They will mention what is outstanding in your claim. Remember, they will be in possession of what you submitted together with the complaint. So if there's anything outstanding, it is important that you submit that together with the claims form, and you will have 14 days to complete that claims form and bring the documents form. And then once the claims officer receives the documents from you, the claims officer may immediately repudiate the claim where the jurisdictional requirements are not met. I gave an example there. I said an example is, if in a particular matter we find that money was not paid into the agent's account but to the attorney's account, and that money is gone, then it will mean now that the claim is being lodged against the wrong person, because the agent had no signing powers on that account. It is the attorney that must account as to what happened to the money. In other words, the claims officer will be repeating the claim and will refer you to the legal practice council for you to go there and lodge a complaint and claim from their fidelity fund. Then if the legal requirements, the jurisdictional legal requirements are met, the claims officer will investigate the merits, require proof of a valid claim, collate the documents, is what we call the PEC, and make his determination within 7 days. In other words, the claims officer will then consider the matter within 7 days and say there is a valid claim against the fund, or my view is there is no claim here. Thereafter, the claims officer will submit that PEC to the claims secretary, who is going to schedule a hearing. So when the PEC will be shared with members of this committee that looks into hearings, into matters. We consider matters individually. We consider each case based on its merits. So if your particular claim has been submitted, the PEC has been submitted, we'll have a date on which we will look into that particular claim. I will be sitting there as the chairperson, as the claims manager, with 2 claims officers and the claims secretary. During the hearing, the claims officer will present the claim to the committee and recommends that the claim be approved or rejected, and is going to provide us with the reasons as to why, how did he arrive at that, and why must we reject or repudiate or we approve the claim. The claims manager, who has a final decision powers, will prepare the outcome of the claim in writing, either repudiating or approving the claim, and give reasons thereof. It is very much important that the reasons be given. Why are we doing this? We are doing this in order to satisfy ourselves that the legal requirements for a claim have been met or haven't been met, to show that we have dealt with the matter as required by law. So because whatever that we are doing, it must be within the confines of the law. Once that has been done, we have our internal process where, as the claims manager, I will present this matter before the EXCO of the PPRA just for an oversight as to whether the claim was determined in terms of the law. The EXCO is not there to make a decision. They're simply there to note that, okay, fine, according to this claim, the law has been complied with accordingly, and that's it. And a resolution gets signed. Once the resolution is signed, which is signed by the chairperson of EXCO, in this case will be the chief executive officer, the claims secretary shall collate the payment processing documents, the payment PEC. This is a different PEC. Remember, I spoke about the PEC that is going to be presented before the committee in order for the committee to decide or to determine whether there is a valid claim or not. Now, this is what we call a payment PEC. The payment PEC, it has all those documents in the initial PEC. It is now going to have what we call the resolution of the EXCO. And further, we are going to have the internal process of enabling the finance department to pay the money. So in other words, I will initiate, if the claim is approved, I will initiate that a particular amount of money be paid to the claimant. And my manager, that is the executive manager in the investigation, mediation, and adjudication department, will then approve that. Then it goes to the CFO. So all these people will be looking into, okay, things have been done accordingly and in accordance with the regulations. And that the secretary must do within 7 days of the oversight. So once an oversight has been done within 7 days, that process must be done. I can tell you, ladies and gentlemen, that since I joined the claims department, I have a very good secretary in Monica. On the day on which we receive the document from EXCO, the resolution, on that particular day, I will definitely get the required documents to be signed and be approved, and it will be submitted to finance on the very same particular day. It doesn't even take 2 days for her. Once that thing is in, she prioritizes that thing, because most of the time you find that the claimants have been waiting for payment. They know we have undergone the process, and she does a level best. And once she has submitted those documents to the finance department, the finance department has a period of 23 days upon receipt of this pack to process and pay the money. And once the money has been paid, the claimant will be notified accordingly, and the proof of payment will be attached on our system, and that will be the finality of the matter. Then I'll go back into the system and block the particular agent, because now the fund has paid the money that the agent has misappropriated. And then we will meet that agent during the period of the registration when they want the fidelity fund certificate. We'll be coming here and say, hey, I don't know why I'm blocked. Last year I had an FFC and so on and so forth. And I'll be saying there was a claim, you failed to respond, and the claim was paid. Please pay this money together with pay this money and give us proof of payment. Then once I receive that, I'll go back into the system. However, ladies and gentlemen, I want to warn you. A person that misappropriates trust money, if that is proven, I will say is not a fit and proper person to be entrusted with money anymore. In other words, if you find yourself in the situation, the question that you should ask yourself is, do I still qualify to be a property practitioner? Because my view is, no, that person can be trusted with money. He can work for an agency, but he can't be the principal, can't be the accounting officer. So in other words, he must not manage a trust account on behalf of the members of the public. Now let's deal with the requirements for a valid claim. In terms of the Property Practitioners Act, the trust money must have been misappropriated by a property practitioner with a valid fidelity fund certificate. It is a requirement. I said in terms of the old act, it was not relevant whether the agent had an FFC or not. The fund, the estate agency fidelity fund, was liable. The Property Practitioners Regulatory Authority Fidelity Fund, if it's found that the agent was not issued with a valid fidelity fund certificate, the fund is not liable. I know I recently dealt with matters where the agency, the principal of the agency passed on around, I think, 2019. The wife continued with running the practice without notifying the authority. They misappropriated monies. When this claim came, the question before me was there a valid fidelity fund issued to this agency and the estate agents? Obviously, firstly, there was no one who qualified as a principal there. So whether they were in possession of a fidelity fund certificate, the question whether it was valid, it's very much important. And I decided, no, there's no valid FFC, because had the Property Practitioner Regulatory Authority knew that the principal was dead, they would have closed down that business and they wouldn't have issued those. So there was fraud committed, and therefore there was no valid fidelity for settlement. And I repeated those claims. Now, the claim must be lodged within 3 years of theft or from date the proof was required. Otherwise, the matter is prescribed, as I said. 3 years, if it's on 3 years on the first day, prescription runs. That is the law. Unfortunately, with prescription, no one has a discretion to exercise. Once a matter has prescribed, it has prescribed. The authority does not have any powers to condone. Even a court of law does not have any powers to condone. The court will simply look at the dates and say, prescription starts to run on this day, and 3 years expired on this day. Anything beyond that, there is nothing that we can do. We can help your claimant. Your matter is prescribed and you have lost. Another important aspect, which was not a requirement in terms of the old act, is that the claimant must open a criminal case with the SAPS and provide those details to the claims officer. In the claims form, there are portions where you are required to answer to, did you open a criminal case? Yes. Which police station? What is the case number? And what is the contact details of the police officer, the investigating officer, and the name of the investigating officer. And as a regulatory body, we communicate with the investigating officers in the matter to understand where's the matter, what are the difficulties, how can we help them, and so on and so on. Importantly, if we go and look at Section 42 of the Property Practitioners Act, it talks about the cooperation by the claimant. It is a requirement that the claimant must cooperate with the authorities. That includes SAPS, the National Prosecuting Authority, the PPRA, and other authorities. If during the determination of the case, it is brought to our attention that the claimant is not cooperative, we have a right to withhold any payment, if there was any payment, until the claimant is cooperating with the police to the finality of that matter. Because why this has been done is that people can go and open a case, and when the NPA is looking for you as the claimant to come and give evidence in court, you refuse to go. So if NPA or SAPS brings that to our attention, or when we communicate with the investigating officer, he gives us an indication that you are not cooperating, or in his notes there in the docket, the road that you are not cooperating, will simply say to you, oh, wait, go back to SAPS and cooperate until finality of the matter before we can deal with that claim. And if you continue, we'll end up repeating the claim. Thank you very much, ladies and gentlemen. This concludes my presentation in respect to the claims against both the Estate Agency Affairs Fidelity Fund and the Property Practitioners Regulatory Authority Fidelity Fund. Thank you very much, Naledi.
Thank you, Mr. Qadim Piepia, for that presentation. I'm going to allow Ms. Geraldine Lingau to flag on her side. What education is a webinar? I saw email yesterday from.
Good morning, everyone. Naledi and colleagues, can you see my presentation?
Yes, I can see your presentation. We can put it on slide mode.
Okay. Right, let me just go back. Naledi, I just want to find out, there are hands from colleagues. Do I just ignore that? What's the
Yes, yes, because we did
Oh.
announce in the beginning we'll deal with the hands after all the presentations.
Okay. All right. Thank you so much, Naledi and colleagues. My name is Geraldine Lingau. I am currently the Deputy Chairperson for the Free State Rental Housing Tribunal. I promise I am not AI. I am very much human. It's just that I won't be able to show my camera and then come back for the sake of time. So today mine is to speak on...
Lingau, sorry about that. Are you able to click enable editing and we put it on slide mode?
Enable editing, where do I find that?
At the top, I see there's a yellow thing. It's restricting you to share on slide mode. Yes, you see there. Click there.
Wait. Okay, when you say there, where's there? By stop sharing.
There's a message on your slide. It said protected view. You see on the yellow messaging. So if you click slide mode, does it allow you on your side to put it on slide mode?
Okay, let's start
for full screen.
Let's do this. Let's start from scratch. Right. Sorry about that. Okay. Share.
Okay, it's fine. I think we can proceed. Colleagues will understand. Let's proceed, ma'am. Thank you.
Right, not a problem. Thank you, Naledi. So mine is to speak on how do we avoid rental disputes. So practically guiding you through complying with the Rental Housing Act for property practitioners. Right. So I intend to cover the following. Number one, what is our understanding of the tribunal? So in other words, are the practitioners who are in the room today understand or know of the existence of the tribunal?
Ma'am, sorry again. Sorry to do this to you. The slides disappeared again. Thanks,
Okay.
technology.
Not a problem. Let's start from scratch, I guess. So at this point, I'm not sure whether I should share my screen or window. Okay, let me do this. And Naledi and colleagues, are you able to see?
Yes, we can see it. We can see.
Okay, I'm hoping that it will not disappear again. Okay. So as I was saying, so I intend to cover the following. What is our understanding of the tribunal, understanding the law that governs the rental tribunals, preventing disputes or bringing information on how do we prevent disputes, and then improving compliance from your end as property practitioners. Right. So why does this matter? So the rental disputes on an increase, and I say this as a person who sits in these hearings/mediations. One, it's a good thing because that means that our communities are much more informed of their rights and where to go. But also, it's a bit of a concern because if disputes are arising, it then means that one of the parties either is not complying or does not know of what their rights and or responsibilities are. So in the main, colleagues, throughout this presentation, the disputes that we'll be talking about have been centered around three focal areas. So number one, these are issues regarding money. So your deposits, your rental areas, your rental increases or your utilities. Number two are the property issues. So damages to property, maintenance thereof, repairs and or inspection. And then number three, which is a very favorite one for tenants, evictions and occupation issues. So herein we address illegal lockouts and changing of locks, cutting out of electricity and or water / spoliation, harassment and notices. Again, emphasis, it's important that we become aware that if we prevent all these, it's always much more cheaper than litigation. All right. So just for information sharing's sake, these are the legislative frameworks that govern all the things that will be spoken about in the presentation. Number one, we can never divorce ourselves of the constitution of our country. And in that, section 26 becomes very important. That speaks to the right to adequate housing. And then, of course, our mother legislation, the Rental Housing Act, with its various amendments. And then we've got the Property Practitioners Act. I think my colleagues spoke on that. And then we have the Consumer Protection Act. And lastly, but not least, we've got PI, Prevention of Illegal Eviction from an Unlawful Occupation of Land Act. All right. So what then is the role of the rental tribunal? So here in short, we have just gotten two quadrants. There is what the tribunal does, and there is what the tribunal does not do. So the tribunal rightfully, according to the Act, resolves rental disputes, but the tribunal does not grant eviction orders. So tribunal also conducts mediation, which is a very voluntary process. I think we're all aware of it, and one of the most amicable and less expensive measures. But the tribunal does not award damages for personal injury. The tribunal does hold hearings, and the tribunal does not decide on ownership disputes. Often than not, colleagues, matters do come to the tribunal where it has got nothing to do with rental, and it's got to do with perhaps ownership issues and or commercial matters, which I think I should have disclaimed in the beginning to say that, as the name suggests, all matters that come to the tribunal are matters concerning rental of properties and not ownership and or commercial leases. And then also, furthermore, the tribunal does issue binding rulings, but the tribunal does not deal with disputes related to commercial lease agreements. And then lastly, our very important role is that the tribunal has to educate landlords and tenants, as is the case with today's presentation. So what is your role? And like I said, I think a colleague answered this, although their presentation was more focused on the issues of claim, but your role as a practitioner is multifaceted. So number one, having to see to the drafting of compliant lease agreements, managing deposits correctly, conducting inspections. I think I'm speaking to the converted, you would know what your role is. Ensuring legislative compliance, keeping accurate records, acting fairly toward both parties, and then lastly but not least, facilitating communication. I think at the center of all the disputes, whether it's in a mediation and or in a hearing, we get to find that there is a broken telephone somewhere between these two parties, and had communication been facilitated properly, we would have minimized the risk that we often find ourselves with, having to sit across each other and resolve disputes. So what are the common causes of rental disputes? So from these two quadrants, there's one, the landlord's issues, and then there's the tenant's issues. As far as landlords are concerned, there's always issues of, sometimes, failure to manage the property. There's matters regarding deposit disputes, whether it's withholding of deposits. Then there's illegal evictions. Then there's utility overcharging. Then there's unlawful rent increases. So here we speak about unilateral increases that were never agreed upon in terms of the contracts that were signed. And when we come to the other quadrant, what are the issues that tenants often face? Rental arrears, property damage, breach of lease, unauthorized occupants, and or failure to report defects. All right. And I must say, sometimes these things are very much intersectional. So you would find that for example, what the presentation is particularly talking about could be either an error on the landlord side and or an error on the tenant side. So it's not cast in stone that these are the only ones that can happen. Sometimes it's multiple at a go. All right. So typically before occupation, what should then happen? And I think, again, preaching to the converted, but we know there has to be a written lease agreement. There has to be FICA compliance. There has to be an incoming inspection, joint, by the way, incoming inspection. There has to be inventory that will be checked at the inspection. meter readings, deposits, receipts, house rules, and copies signed by both parties. All right. Then as far as the lease agreements are concerned, and I think many of us who may have studied law will understand that there are the definite requirements of what makes a contract valid. All right. So these are the things that lease agreements typically should have at all material times. So what is the rental amount and the due date for payment? Believe it or not, but disputes do come in because of a unilateral changing of agreements and or having set no date for payment. What is the deposit? Is there a deposit? Where is the deposit placed? And I think our speaker spoke about this previously. Maintenance and repairs, duration of the contract renewal and or cancellation, the utilities, the inspection requirements, the breach procedures, and notice periods. Okay. So as far as deposits are concerned, what are we looking at? So the Rental Housing Act requires that deposits ought to be invested in an interest-bearing account, that the interest must accrue to the tenant, that there must be a record available on request, there must be joint incoming and outgoing inspections, and there must be a deduction supported by evidence. So whenever there are deductions, it has to be supported by evidence. And I think this ties so beautifully with what we had said when we spoke about the multifaceted culture and or nature of property practitioners as far as these disputes are concerned. And we spoke about communication. So if there's communication, then all of this, particularly the last point, deduction supported by evidence, will not be a thing that we'll have to always, when we are in hearings, which I see in practice, have to defer a matter and then bring evidence back. But if communication was timeous, then all of this should have been or would have been sorted out. So with this slide, the important thing to take home is that failure to comply is one of the tribunal's most common complaints. And like I said, failure to comply either by the tenant and or by the landlord. Okay. Inspections. We know that we are required, to have incoming inspections before occupation. It has to be a joint inspection, because then how then do you know what exactly was a defect at the time of moving in and what then becomes a defect at the time of moving out? There has to be a record of the defects if they are. We would encourage, and I think you also would encourage as a form of good practice, taking photographs so that you can be able to attest to the fact that this is what we had observed at our incoming joint inspection. And then there's outgoing inspection within the prescribed time. Obviously, that will be detected by your lease agreement. It has to be joint and you have to compare it with the original. Next slide. All right, maintenance responsibility. So what's your responsibility as a landlord? As far as maintenance is concerned, there has to be structural repairs as and when is necessary, the plumbing, the electricity systems, water leaks, and habitability. All right. And from a tenant's point of view, it's a tenant's responsibility to report defects promptly. It now doesn't help that a tenant does not report a defect, and only when moving out does the defect now come to the fore. Keeping premises reasonably clean. Many matters come to the tribunal with health hazards in it as a result of this very point. Then there's also your responsibility as a tenant to prevent avoidable damage. Communication prevents disputes. Again, that very slide that spoke about timeous communication. And then rental increases. So what is the best practice as far as rental increases are concerned? Number one, follow the lease agreement. That which you both agree to in black and white, it would be great to follow that. Give proper notice. So no unilateral changes to an agreement. Be transparent. Explain the calculations. Avoid arbitrary increases. So this point of explaining calculations, often at times we sit in hearings where now only is a tenant and or landlord, coming to the tribunal and trying to explain how these things were calculated when it was never discussed between the two parties to begin with. And again, saves a lot of time, saves a lot of cost if we can just be transparent and communicate timeously about rental increases. Utilities. So the common disputes arising from utilities are usually the electricity, issues pertaining electricity, water, refuse, and or sewage. And I must say, with the utilities part, which I said in the beginning, we'll cluster the common problems that come to the tribunal under utilities and all of that, is that here we find that obviously spoliation orders, right? Where a landlord decides that, listen, because you're not paying your electricity on time, or rather you're not paying your rental on time, we then will cut off your electricity. And that, by the way, is a very urgent application that's made to the tribunal that must be heard timeously, or rather urgently. Because one, obviously, spoliation and or locking out and or cutting electricity and water, you are now depriving the very person who lives in your property of their constitutional right to have this. And I know the counter argument would be, but what about my money? Because also this is a commercial business. However, don't shoot the messenger. I'm here to promote awareness. So what is the best practice? Best practices as far as utilities are concerned would be, again, meter readings, but also transparent in your meter readings, monthly statements. And again, this is not just the responsibility of the landlord, but also the tenant must be able to have monthly statements that I suppose, inspect. And if they have a query about it, approach the landlord, approach and or the municipality and request adequate explanation thereof. Municipal tariffs, and then transparent calculations. So never estimate without disclosure. And I find that a lot of these we've seen in the recent past come from places where students are renting. And they now come and they want to know, as far as utilities are concerned, what is a best practice? Can my landlord do this? What is my responsibilities and what is my rights? And then unfair practices. So as mentioned previously, examples of unfair practices would be illegal lockouts. This is where a tenant, or rather a landlord, locks out the tenant from, staying inside their premises. Disconnection of electricity, we spoke about that. Harassment, and not sexual, please. Harassment, verbal. Entering property without consent, it's an unfair practice. Withholding deposits unfairly, and refusing inspections. So these may amount to unfair practices under the Rental Housing Act. Right, then at the end of the lease. So here now your tenant has had a good stay and they're about to leave, or they are leaving as according to what they have both agreed on. Best practice would be there should be proper notice that they give. There should be a final inspection, remember, joint, outgoing, have evidence, photographs, meter readings. Tenant must have satisfied themselves with, all of these. Deposit reconciliation, a written statement of deductions, and a return of the keys. Right, a fun fact, the evictions, it's very important to know that a landlord may not lock a tenant out, may not remove a tenant's belongings, may not disconnect services, and may not change locks. I keep on emphasizing the may not, but I know that policy doesn't always meet practice, because sometimes tenants, or rather landlords, are just fed up with the tenants, and they then resort to taking the law into their own hands in this regard. Please note that this is an unfair practice and it warrants to be heard urgently at the tribunal. Lastly but not least, as far as evictions are concerned, only a court may authorize an eviction. Again, to those that have studied law, you would know that this is a whole process that has to be satisfied with the courts. All right. So what are the practical tips that we as a tribunal can give to prevent disputes? The one that's been sung the whole time has always been communicating early, documenting everything, and this is both the responsibility of both the parties, following inspection procedures, acting consistently, being transparent, knowing the act, and using mediation. I must just pause here to speak about the using of mediation. So so number one, we all know mediation is an alternative way to resolve disputes, but it shouldn't be frowned upon, because one, it's very quick, and it's also to the benefit of both parties, especially when we deal with issues of unfair practice in the form of your lockouts, your spoliation orders where a person has been deprived of electricity and or water, as opposed to now coming in for a hearing, which also has got its own procedures and timelines that must be complied with. So we encourage, as a practical tip, whenever all of these disputes that give rise to a matter coming to the attention of the rental tribunal, mediation is always a best form of recourse to begin with. So then, colleagues, what are the benefits of compliance? Needless to say, you create better relationships through complying and through having a better understanding of yourself and your tenant and or landlord. You have happier tenants. You've got fewer tribunal complaints, but less money for us. You've got reduced litigation. I don't think, I know in the rise of everybody knowing what their rights are, which is beautiful, but it's very costly. However, case sera to each his own. We, however, advise that to comply would be beneficial for you because it will reduce the cost, the time, and also it creates a better reputation for you. I think most of us in this platform are people that are running businesses. So having to endure the cost of non-compliance, I think it's quite something negative for your business. And then lower financial losses as well. So colleagues, compliance, I think with this slide, the important thing is just to note that compliance is good for any business. And at the center, I want to continue to emphasize that it's always about the communication that gets lost somewhere in the middle. I'm not saying that tenants can also not be people who comply, but I'm just saying communication. So what are the key takeaway points from this particular presentation in as far as compliance with the Rental Housing Act is concerned? Remember that prevention is cheaper than litigation. Documentation is a strong defense. Conduct inspections, handle deposits correctly, never perform self-help eviction, and follow the Rental Housing Act. Now, lady, I hope I did justice. I'm now done. Thank you, colleagues. That concludes my presentation.
Thank you so much, Ms. Geraldine Lingao, for that presentation. I'm going to allow the questions. Let me allow you to drink some water. I'm going to start with Mr. Mpiepia's question, and I'm going to allow the hands. We will unmute line by line those who raised their hands. I have a question for Mr. Mpiepia from Liven. Does the EXCO have sufficient legal knowledge and experience to determine the final decision on a claim? Kwadi?
Thank you very much. As I indicated, the EXCO does not determine a claim. A claim is determined by the claims manager. I said we take matters to EXCO only for purposes of an oversight. I must indicate, however, that in our EXCO, we have 3 experienced legal practitioners. We have Advocate Vialde, we have Mr. Clarence Ketten, and we have Mempahele. So we have 3 experienced legal professionals in our EXCO department. So they are there only for purposes of an oversight. The decision on the matters is within the powers of the claims manager, as I said. Thank you very much.
Thank you. Let's go to the hands. Emma, please unmute yourself and ask our speakers your question. Emma? Okay, I'll come back to you. Let's try Tyron. Please unmute. Okay, maybe there could be a delay on their side. Let's go to Ramarwaneng. Please unmute. Okay, let's try Viloshni. Please unmute yourself. Okay, maybe they can't hear me. Let's go to Dineo. You all have access. I've given you access to unmute your mics. Dineo. Okay, let's try Fran before we go back to the chat and take the questions. Fran, please ask.
Thank you. I have a question. If the agency has misappropriated the deposit, can the agent then still be held liable and her FFC be taken away?
Mr. Mpiepe?
Let me understand you, ma'am. When you say the agency have misappropriated the, let's say, the trust money, the
Yes.
question is, can the agent be held liable?
Correct. So the agent has the tenant has paid the agency the money, the rent, the deposit, and the
Yes.
agency has not put the deposit into a trust-bearing account or into a trust account. Can the agent still be held liable for that if it was the agency's responsibility?
Okay, let me put it in this manner. The agent that you are referring to now, are you referring to a non-principal agent?
No, sorry, just repeat that.
You're asking if the agent can be held liable. I'm saying to you, are you referring to the non-principal agent?
Yes, so I'm talking to a normal qualified agent that has a proper FFC, and obviously they're working on behalf of the landlord, the tenant, and of course the agency. Then the money gets paid into obviously the agency's account, and the agency needs to take that money and put it into a trust account. But let's say the agency didn't do it.
Okay.
The agent who has brought this tenant, surely they cannot be held liable for the agency's misappropriation.
Okay, let me explain it in this matter. When we consider the matter, we are going to have a look as to how was the money or where was the money paid. If the money was paid into the trust account of the agency, the trust account that is opened in terms of Section 54, and the Property Practitioners Regulatory Authority was notified of in terms of Section 54(1. The accounting officer, which is the principal in this case, is the person who is responsible to manage that account. So that account has nothing to do with a non-principal estate agent. So the non-principal estate agent that you are referring to wouldn't have committed any theft. The theft would have been committed by the principal as the signatory in the particular trust account. Do you understand each other?
Yes.
So
yes.
What will happen that in my case, I will look, the requirements will be met because the agency and the principal also had the FFCs. I will say the requirements have been met. If all other requirements have been met, I'll settle that. But what the legal department is going to do, that is Daly's department, is going to charge the principal. They'll look into the facts and say, despite that this non-principal estate agent is the cause of the lease of this property practitioner, it's not the one who misappropriated the money and has nothing to do with the money. Money was paid in the trust account. They won't charge that particular agent because he or she didn't steal the money. They'll charge the principal as the person who took out that money from the trust account. Do you understand?
Yes.
Yes.
I've got one more question, if you don't mind.
Yes, please.
In an agency, can an admin or an accountant that has no FFC advertise and do any kind of viewings for properties that are to rent?
No, that is illegal.
Okay.
It's trading without a fidelity fund certificate, we will charge. And we will also charge the principal of that particular estate agency because he allowed a person who's not been issued with a fidelity fund certificate to practice as such. If you look at Section 48, subsection 2, it gives us the powers to charge the principal. Some they call it vicarious liability, but I don't call it vicarious liability because the Act specifically tells us that we can charge the directors and the principals for allowing people to trade as estate agents without a fidelity fund certificate. The fact that that person is an admin or an accountant, it means nothing to the person who's looking into the matter. The question is, what is it that this person who's called admin has done? If he has advertised a property or took people for viewing, that is within the scope of a property practitioner, and that admin must have an FFC, and therefore we will charge this person you call an admin and charge the principal.
Okay.
Yes.
Thank you very much.
Thank you very much.
Thank you for that. And also maybe to add, Mr. Mpiepa did explain on the presentation, there's a process of lodging a complaint, and you can also be anonymous if there's an agency or an agent you want to complain against. It's on the portal where you can submit your complaint form, which it will go to the IMA department that he mentioned earlier. I have another question. What is the guarantee? It's coming from info. What is the guarantee the claimant will get the necessary confirmation the property practitioner has a valid FFC accurately and timelessly? What is the guarantee the claimant will get the necessary confirmation? Because there's an error there. Then he says the PP, which is property practitioner, has a valid FFC accurately and timelessly. I think you are trying to say in relation to lodging a claim, info, city properties. Am I getting your question correctly? Please come through and unmute if I'm not getting it. Kwadi, did you understood the question? Maybe you can try to answer.
Yes, Naledi, when the members of the public contact our office, what I expect is that the people that are being contacted, that will be a call center, they will then go into the system and look into the FFC history. We call it the FFC history of the particular agency and the agents registered under the particular agency. And they will check the validity of the FFCs as to when did they apply, when were the FFCs issued, did they meet all the requirements. Then once that is done, then they can advise a member of the public that indeed, yes, this agent has a valid fidelity fund certificate. And this process is different because I've worked in legal department first. There are people who will come to us and say, we require confirmation. This is different. Remember, at the stage where we are saying you are mandating an agent, you are not required to have confirmation that somebody. It's to call the PPRA and say, I just want to check this agency if he has an FFC. I want to give him a mandate, or we are entering into this particular type of contract. Then those people, they should confirm for you that there's an FFC. They may, under the appropriate circumstances, provide you even with the FFC number to say, this is the FFC number. It was issued, let's say, for example, in 2024, it's a 3-year FFC. It's valid until 2027 or 2026, end of 2026, which is 3 years. So you will then mandate that person based on confirmation from the PPRA that this person has an FFC which is still valid.
They have a follow-up. They're saying, how long will this entire process reasonably take? What is the turnaround time for the PPRA and the claims officer? What are your turnaround times in the claims unit?
Ladies and gentlemen, claims, they are, I call them, they're easy. And within 90 days, a claim should be finalized. Unless if there are issues, there are some matters that are before court. There are some matters that require to be dealt with extensively. We will always communicate with the claimants in those cases if they're taking more than 30 days and give reasons why we are taking longer into those. But a normal case, within 3 months, we should finalize that, ladies and gentlemen. Within 90 days, the law says 90 days. And I can attest to that, ladies and gentlemen. There are matters that we finalize even within a space of a month or 2. I normally have those matters that we quickly find. You find that when the complaint is lodged, then the matter is escalated to us. When that matter goes to the claims officer, everything is in there. Then the claims officer within 7 days says, I'm happy, I have everything. I can bring this matter to the committee. We look into the matter. It's a straightforward matter. And the agent decided not to respond to that when afforded an opportunity to do so. We quickly deal with such matters. So the law says within 90 days. It's only 3 months.
Okay, thank you for that. I have a question for Ms. Lingau from Colleen. Says, if the tenant does not have a fully signed lease, does this mean it is now a month-to-month agreement?
Hi, Naledi, thank you for the question. Yes, definitely. Then we resort to common law. Correct.
Thank you. They're also asking for your contact details because they're saying they went to the website and they're struggling to get through to rental tribunal as well. I'm gonna go, and I think on the slides, colleagues, because we're going to share the slides, the contact details are there at the end of the presentation. You will see them for both our speakers, but we can also maybe share on the chat as well so that you can know who you can contact on how to lodge the complaint with the tribunal. I'm going to go to the hands. Emma, please unmute yourself and pose your question, Emma. Okay, Taren. Okay, Ramarwaneng, please ask. I'm going to lower your hand if you don't ask, and we're going to mute you again. Let's try Dineo again. Dineo. Okay, let's go to Pulmo Properties.
Good day, everyone. Do you hear me, Naledi?
Yes, we can hear you. Please ask your question.
Okay, thank you very much. In rentals, we have the managed rentals and unmanaged rentals. So in unmanaged, that simply means the deposit, it will go direct to the owner. So that simply means I'm asking that, is the owners allowed to accommodate the deposit? Thank you very much.
Ms. Lengau.
I'm not sure I follow. So there is unmanaged and there is managed. So with
Yes.
unmanaged, come again, please explain again. So the unmanaged, how does that work?
In an unmanaged, that simply means the agency, it will only receive the placement fee. Then after that, it will be out of the picture. Then we are going to have the deposit money that it's supposed to be trusted. Then that simply means that money goes direct to the landlord. So is it that one allowed that the deposit, it will go to the direct to the landlord? While we as the agency will only receive the placement fee alone only.
Oh, okay. That's the first I come across that. I don't know. I have no idea. Because the common understanding as far as deposits are concerned would be that a tenant pays deposit upon moving in, and as according to the lease agreement, when they move out, they're allowed to get their deposit, provided that, as according to the contract itself, there are no damages and or defects that the deposit pays for. And obviously the additional element of that deposit having been placed in an account that is interest bearing. I'm not sure about the managed and unmanaged. If there are colleagues that can assist there, I'd be happy, but I'm not sure, so I don't want to lie to you.
Okay, can I follow up this one? That simply means if the clients decide, or both of them, they decide that the deposit, it can be held into the landlord's account. Then after the lease, after 12 months, the deposit, it's definitely available. So that's not a problem, right? With the guarantees that the deposit, it will be available after 12 months.
Okay, Ms. Lengau, I managed to call the IMA manager quickly who deals with these matters. Are you okay if I allow her to answer?
Okay, continue, ma'am. Yes, you may.
Okay.
Okay, so in terms of the deposit issues, if the mandate between the agent and the landlord is that the agent will not manage the property, but only collect a placement fee, then the mandate should specifically state, and the lease agreement will then be specific to say the deposit will be kept by the landlord in an interest-bearing account, because the landlord is also required to keep the deposit in an interest-bearing account, which means then the tenant is now aware that when he leaves the property, he will request his deposit from the landlord and not the agent. So where there is a mandate that the agent is not going to manage the property, then usually that is the arrangement. And there is nothing wrong with that arrangement, because remember, these are contractual agreements. As long as the contract complies with the Rental Housing Act, then that agreement is okay. Thank you.
Okay, Mr. Pulmlo, were you answered? Can I move to the next question?
Yes, ma'am, I've been answered, but I wanted to follow up with a certain question quickly here.
Okay.
I think I joined late. So I wanted to know if clients breach
We can't hear you.
contract.
I think you went low.
Yeah. Do you hear me now?
Yes.
Yeah, I just joined late, but just to follow up quickly, if the clients breach with the contract, you said they're supposed to go through the legal route. You don't have to evict them illegally or block whatsoever, just hear that. But that simply means we have to take them to court. The owner, the landlord, supposed to take them to court for
Okay, so Ms. Lingau, the breach of contract.
Yes, I heard him, my lady. Hello?
Yes.
Oh, yes, ma'am. You may continue.
Yes. Okay, so no, I heard sir when he spoke about the breach. So number one, it depends on what the breach is, but your legal remedy would be, number one, to enforce that you would have to approach a court, a competent court, and or you can come to the tribunal. So we need to discuss, or rather we need to establish what exactly was breached in that contract. But it is an unfair practice for you to take it upon yourself to, let's say, for example, they didn't pay rent and then you lock them out. That's illegal lockouts, and that is deemed to be an unfair practice. It is an unfair practice for you if you then decide also to switch off their electricity and or their water. So those three that I mentioned are often the unfair practices that the tribunal will sit in and make urgent rulings on. I hope that answers your question, sir.
Yes, it answers. Just
Okay.
the last one. So
right.
who will be responsible for the cost, the legal cost?
The tribunal is free, sir. There's no cost for that as far as the tribunal is concerned. It's a free mechanism.
So if the landlord wins the case, that simply means they will make the tenants to pay all the monies that has been defaulted, right?
You may.
Sorry?
I'm saying if
Yes, ma'am.
I no, I didn't hear him.
Mr. Pulmo, can you say that last question? You're saying what are they paying for, the tenants and landlord?
The landlord, I was sure I just lost this one as well. I was asking about the legal fees and you said it's for free.
Yes.
Yes, and when you approach the tribunal, correct. And then your follow-up was?
No, let's pass this one. I just
Okay, let me go back to the chat. If you remember, can I ask that you raise your hand again? And maybe also, I can imagine the stress when you have tenants who don't pay. This is why it's important to do verification. You make sure that you get the tenants who can afford to pay, rental into the property so that we don't get to the stages of going to court and rental tribunal. There's a question. I was lucky because Daily sits next to me, so I managed to get her to come quickly if she can assist with some of the question because it overlaps from claims to her IMA question, because this one from Kingsley, if Daily, you can help me with this one. He says, I'm going to read it out loud for record purposes because some people are going to listen to the recorder. What would the situation be when a property practitioner has applied for a renewal of their Fidelity Fund certificate? However, they have not received it and there is a rental dispute?
Okay, so if the property practitioner has applied for their FFC and hasn't received it, what we will then do as a PPRA will check whether we've received that application and the reasons why it has not been issued. If the FFC was supposed to have been issued and there's been a delay on our part, then we will be able to communicate to whoever has lodged the complaint or whoever the agent has a dispute with that the agent was entitled to an FFC at the time. If, however, the person has applied for an FFC and the FFC is non-compliant, then that FFC would not have been issued at the time, and we'll also communicate. But should there be a complaint that is lodged with us against a property practitioner who was entitled to an FFC, we will be able to deal with it and will not discipline any estate agent in that regard.
Okay, thank you. The queries and the questions of FFCs, I'm not going to read them. I will just reply on the chat because today we don't have FFC team in the webinar. We have Mr. Kwadim Pieper coming from the claims unit. He deals with legal matters. So let me go back to the hands and let's see. Rochelle, please unmute and ask your question.
Good morning to everybody. I just wanted to say thank you for such an informative session. My question is for Ms. Geraldine. I've actually got two questions. The one is the tenant is busy moving out. While they're busy moving out, the landlord comes and changes the locks. That's my first question. My second question is, if a tenant moves out before the term, before his the lease ends, I mean, in today's life, things happen, and you can't afford the. In our lease agreement, there is there are penalties that can be charged. I just wanted to know about the penalties because, as far as I know, and that could be very little about this, is that the landlord can only charge a tenant penalties for whatever monetary he loses. Am I correct in saying that? Thank you.
All right, thank you, Rochelle. So with the first question of the tenant moving out, that does not constitute an unfair practice because I deem that they're moving out because their contract has come to an end. So the locking out would not prevent them from having their possessions or unlawful seizure thereof. And then your second question was, before a lease ends, a tenant moves out, and now there's the issue of penalties, correct? Rochelle?
Yes, I am. Yes, I am here. Yes.
Okay.
So the landlord is saying, well, I'm losing a tenant. If I don't find a tenant with an X time period, I'm going to charge you an extra month or 2 months rental. I just wanted to know how fair is that?
Okay, so I think we need to go back to what did their contract say? What was their lease agreement? So if those clauses are provided in their lease agreement to say that these will be the penalties should you move out before your time, then I think complying with that would not constitute an unfair practice. But if it is a unilateral agreement that they take upon themselves, then that could constitute an unfair practice.
Thank you so much.
Rochelle, okay, thank you so much.
Thank you. Thanks so much.
Ms. Lingau,
That
I have
answers my
another
question.
Thank you. Ms. Lingau, I have another question coming from Tanya in the Q&A space. Can a tenant make contractual changes to a lease and insist that we comply with it?
No, that's unilateral again. Let's just go back to the presentation where we shared that where there is an agreement that has been agreed upon by both parties, then safe to say those are the rules, rights, and responsibilities that govern that relationship. So there could be an agreement that they both look into how about this is how we conduct our business, but not one person solitary on their own deciding to govern the relationship for both parties.
Yes. Thank you for that. Let me go to Ipileng. Please unmute and ask your question. Ipileng? Ipileng? Please ask. Please ask your question. I see you are unmuted. Okay, check your volume and come back. Let's go to Marie. Marie, please unmute and ask your question. Okay, let's go to Morokwane. Please unmute and ask your question. Morokwane.
Yes, thank you for the presentation. I have two questions, one for about the claims. I just want confirmation about the new act. Does the claim also pay for the fly-by-night agencies? I just want clarity on that because I saw on the old act it does pay. And then the second question is about the tribunal house. Let's say I took a tenant to the tribunal house, a non-paying tenant. Let's say, should it happen that they promise to pay at the tribunal and then they don't pay, and what is the next step? Must we go back to the tribunal? And does it also mean that if I take the non-paying tenant to the tribunal, will I have guarantee of their payment? Or if they fail to pay, what is it that I can do?
Thank you. Let me allow Mr. Mpiepia first to touch on the validity.
Thank you very much. The fly-by-night, my sister, I'll assume you are referring to property practitioners that are trading without being issued with fidelity fund certificates.
Yes.
I have indicated that in terms of the Property Practitioners Act, for a claim to be paid by the fund, the estate agent that has misappropriated the money must have been issued with a valid fidelity fund certificate. So anyone who does not have, once there is no FFC, the fund is not liable.
All right, thanks.
Thank you, Ms. Langau.
Thank you, Ipileng. So you're talking about a rental default. So when you do, so firstly, yes, you can bring a tenant who defaults on rental and the matter will be heard in the tribunal. So the important thing here is that that order or that ruling that we give usually is given a certain amount of days to comply with. This will be now, the tenant will be given an amount of days to comply with. In the event that they don't, we usually quantify the amount that's outstanding. You can then take that particular ruling and enforce it with a court of law because we've got the same jurisdictional powers as far as enforcement is concerned with a court of law, with the magistrate court, I beg your pardon. So to answer your question, Ipileng, when there's rental default matters, you can bring them to the tribunal. Secondly, the matter will be heard and the tenant will be given a certain amount of days in which they must pay you. In the event that they don't, then we can enforce that order. How do you do such? You may then approach a magistrate's court who will then help you to enforce that order, especially because we would have quantified how much is the outstanding rental. Thank you, Ipileng.
Thank you.
Let's go to Fran. Please unmute. Fran. Okay, Hiralal. Colleagues, you have access to the mic. Hiralal, please unmute. Okay, let's go back again to Marie.
Hello, sorry for now. I have a question. My tenant passed away on the 25th of May. I heard about that only on the 7th of June. His wife was in the apartment. I know I can't pay out the deposit before they've got executor, but they're not going to have one because he didn't leave a testament. So now this deposit is sitting in paper. And I don't know how to get a legal permission, from who to get the legal permission to pay out the landlord for the missing rent and the widow the rest of the stuff.
Okay, that's an interesting question. Ms. Lingau, the tenant passed away.
Interesting. So the tenant was staying with their spouse.
Yes.
And the spouse is still staying there.
No, she moved out at the end of this month. So
Okay.
that June actually now the 1 month they owe us rent. Because they didn't give us notice. I don't know. The contract says that they end next month the rent would have been ended, but they also he signed a renewal. although we knew he had cancer and he had 2 months, he didn't prepare a will and he signed the renewal. But that's not the problem. We've got another tenant in from this 1st of next month. I just want to know what to do with the deposit. How may I legally pay out the deposit to the landlord, his part of the rent, and the rest to the widow? Or may I not?
Interesting.
Or where can I get advice or help?
I'm trying to think of, because this is not an actual dispute in the correct sense of the word. Nobody is bringing a complaint before the tribunal, correct? It's just you seeking legal advice. So in your lease agreement, there were no terms that provided for eventualities like this. That's the first. The second would be just as a form of advice. I don't know, maybe there are colleagues here in the chat who can assist, but have you had the conversation with the spouse that's surviving?
Yes, I did. I usually let the people sign a permission form to pay out the deposit.
Correct.
But we don't know if she can legally do that because she's not under contract. And the son is very agitated at the moment. He wants to take me, I think, I don't know where he wants to take me, but I want to help him, but I don't know how. He's aggressive because he sees the deposit is going to sit there forever because they don't have a will and they don't have an executor. So I don't know what's the next step if there's no executor.
Ms. Lingau, can we answer?
You may, ma'am.
Daily.
Yeah, let me try. Usually, remember the agreement does provide for the fact that the landlord will be entitled to deduct against the deposit if there is outstanding rental.
Yes.
So that agreement in respect of the deposit will stand. I know that your issue now is that you require something signed to say the deposit can be released. Is the surviving spouse willing to sign that? Because if they're married in community of property, then it doesn't matter that one person signed. Because remember, you bind your spouse if you are married in community of property.
Yes, she is, but she can't find a marriage certificate. I also asked that.
She can't find what?
A marriage certificate to prove that
Home
they
Affairs.
were married in your. So she's trying to apply and get that from, I don't know who, but yeah. That will take months. And I mean, I had 14 days, which is now running out. So I'm just worried that I'm going to get in trouble with this deposit sitting here and going nowhere. It's
No,
safe
let
because it's
him
a
get,
paper.
yeah, I don't know how long that will take in terms of getting the marriage certificate, but there is a contract in place, and unless you want to just ask your lawyers to really advise you what to do, but I think there is a solution to that.
Okay, so I must ask the lawyers.
Yeah, just so that you are certain. But for me, the contract gives the landlord the right to collect the deposit, and the fact that you just have a procedure outside of the contract does not mean that the contract is not valid. So you are enforcing a process that is outside of the terms that have been agreed upon, and you want to enforce it onto the contract. I'm not sure if that's going to work, and the landlord might have a claim against you because that's what the contract says, and you are now wanting to impose a process on top of the terms and conditions of the contract. But just get an advice from an attorney.
Okay, thank you.
Mr. Mpepe, I saw your hand, or can I maybe move? You wanted to also add?
Yes, no, I think you can move.
Ms. Lingau, you can come through.
Yes, Ms. Naledi, there are questions about the tribunal. I did try and type it there, but also I just need to emphasize that every province has got its own tribunal. So for the sake of our tribunal, my response is then there in the chat box. I gave the address and the officials, usually our case managers, which are the people to approach.
Thank you so much. Colleagues, please check on the chats. Let's go to Hiralal. Please unmute and ask your question.
The rent deposit that you collect, must be held only in an interest-bearing account, or can just hold it in a trust account that doesn't bear interest? And if you have multiple tenants, do you have to keep them in separate interest-bearing accounts, or do you keep them in one particular? Can keep them all in one account? And the other question is, if somebody who doesn't have an FFC introduces you a prospective tenant, are they entitled to any commission? Thank you.
Thank you, Mr. Mpiepa. Different tenants, different trust accounts. The trust account, please assist with that one.
Okay. Thank you very much. I think different tenants, different trust accounts. If you look at the provisions of Section 54, it says you as a property practitioner, so you are required to open one or more trust accounts. I think it's a business decision that you have to make, but my advice would be, for purposes of investing money, open separate investments, trust investments accounts for the clients, so that you know, if, for example, if you invested 10,000 rand, it gives you interest of 800 rand per annum. So it will be easy at the end of the lease to know how much interest did that particular tenant earn. Because if you throw them into one account, it's going to give you a lot of work. You will require the accountants to come and work on that particular trust account in order to pay each and every claimant or the person who deposited the money, his money together with the interest. So I'm saying for business reasons, it will be advisable to open a separate trust investment account for each and every client.
And what happens if you keep them in a trust account that doesn't bear interest?
Look, if you put money in the trust account, it's not an interest-bearing account. That depends on your instructions. Remember, then you may be instructed to invest that money. For example, in lease agreements, normally the tenants will instruct you to invest that for the term of the lease. If it's 12 months, they'll instruct you to invest it for 12 months. If it's 24 months, they'll invest you to do that. So I'm saying, if you have instructions to invest the money, invest that into a separate investment.
Thank you. We have 6 minutes before we close the webinar. I'll take the last one question on the chat. Friend, please ask your questions. You can unmute. Yes, buddy.
I think there was a second question from the speaker. There was a second question towards the end. I think it was talking about the payment of commission.
Okay, you may proceed.
As to whether an estate agent that does not have an FFC is entitled to commission, the answer is no. If an agent trades without a fidelity fund certificate, commission is not payable to that agent. Whoever is in possession of the money must pay that money into the fidelity fund. So the money comes to the PPRA, and then it will be for whoever believes that that money belongs to him to claim it from us, from our fund.
So you can't pay a spotter's commission to a person who has an FFC.
I don't hear you say. I don't know whether the volume is down or what.
I'm also struggling to hear some parts. Maybe that's why I missed the other question. Can you please repeat your question?
If somebody who hasn't got FFC, but just introduces you a client who wants to rent, and you get that client and you let the premises out, does that person get any commission entitled to legally?
Mr. Mpiepa, I don't understand the question.
Somebody introduced a client to you as a property practitioner.
Yes.
Whether that person is entitled to commission?
Yes.
No. It's not entitled to commission. An agent is not expected to share his commission with anyone. If you are an estate agent, you have an FFC, the commission will belong to you as an estate agent, not to any person who does not have an FFC. Is not entitled to commission. And if the deal is concluded by the person who does not have an FFC, we are saying the commission that is stated in that particular contract must be paid to the fund. We will write a letter to that effect. If the conveyancer is in possession of the money, we'll write a letter to the conveyancer. If you are in possession of the money, we'll write a letter to you and say, pay that money into the fund. And if you fail to pay that to the fund, the Dailies department is going to charge you for refusing to do that, because it becomes an offense.
Thank you.
Thank you very much.
Thank you. Let me go to Fran. Please unmute, Fran. Please unmute. Okay, Alche, please unmute. Okay, let's go to Sherwin. Okay, I'm
Good
gonna
morning.
go. Oh,
Good
yes,
morning.
please ask. Yes.
Good morning. This is just a question in regards to the Rental Housing Tribunal. I have a few follow-up questions. Just in terms of the time frame it takes for us to get a case heard, I just want to know why the case is taking so long. I mean, if we log it with the tribunal, it's taking 3 to 4 months just to get a hearing. I'm sure there should be ways and measures to ensure that cases are heard sooner and better. My next question, if I can just say quickly, is, I represent a lot of landlords in the tribunal, and I want to find out, some of the people sitting in the tribunal are educated and well represented. My problem is that between the law, the acts of the tribunal, and between the issue at hand and between the lease agreement, they are not tying the knots, and you find that their judgments and their rulings is definitely not in line with the way we're expecting it, and in terms of the lease agreement. So if I can just get some comments on that, thank you so much.
Okay, thank you, Naledi. To answer the issue of time frame, I don't know where Sir is calling from, but I would speak from the Free State Rental Tribunal's point of view. So how, and I'm sure you would appreciate this, having said that you also sit in tribunals. So how I understand it, yes, sir. So how I understand it to work is that there are those matters that are deemed urgent, which of course will fall under the unlawful practices such as illegal lockouts and spoliation orders. That, as far as my tenure is concerned, we've tried to address with the necessary agency. But also, I will not take away the fact that there are many, many places that the Free State services. So, for example, in Bloemfontein, we don't just service tenants and landlords in Bloemfontein. It's the entire Free State that we service. And we're currently sitting with only 2 administrative officers, of which if one goes on leave, we'll need to now depend on this one and her mini structure of officers that assist them. So that's as far as timeframes are concerned. I can't say it's a good thing. It's not a good practice, I understand, but also appreciation must be given to the fact that when we speak about a province, that's why we continuously go out and say we need information officers in our municipalities that will assist us in the backlog of matters that we have. Right. And then your second question relates, I think, more to operations and how people within, the tribunal itself deal with matters. I don't know whether it's a proper platform to ventilate, my understanding and interpretation and application of a particular case with the law. Perhaps that would warrant for a different platform. But also, sorry, Naledi, can I just monopolize the platform? Kutlwano Bohloko had asked a question. So Kutlwano, to answer your question on how do we assist you when you have a tenant or a tenant, I beg your pardon, that does not pay rental and refuses to pay their rental. So basically a difficult tenant. I think first and foremost, you resort to the normal contract law guiding principles. So you write to the tenant, you write them informing them timeously about, the outstanding rental. The matter can be brought to the tribunal, an order will be made in the tribunal, but in the event that they still fail to pay the rent, which has happened, then there is nothing that prevents you from canceling the lease agreement as it stands. I don't think you should be afraid to enforce your rights as well as a landlord in that regard. Thank you, Naledi.
Thank you for that. And I also want to thank Ufenze for assisting in replying the questions in the Q&A space. Thank you so much, Ufenze, for responding. There's other 3 questions. I don't know if you want to look at them, Ufenze, to assist in responding them in the Q&A. We have not read them out as yet. There's a hand, Ruvashni, please unmute and ask your question. Ruvashni, our last hand.
Good afternoon, all. Thank you so much. It was such an informative presentation. Thank you to the team for putting this together. I just want to find out, there was a note that no commission must be paid out if you don't have a valid FFC. What happens to spotters commissions admin staff that bring in deals and obviously you want to pay a commission, are you allowed to or not allowed to now? I presume that it was okay all this time. If you can please help me with that.
Hello, ma'am, can you repeat the question towards the end? I didn't get that.
Okay, so
What
I'm
happens
saying, thank you, sir. So I'm saying that there was a comment made that no commission must be paid out if you do not hold a valid FFC. So
Yes.
if you have spotters commission, referral commission with clientele that do not hold an FFC, if my admin lady comes in with a deal, am I not allowed to pay her commission? Is she not entitled to commission, or is there a different way that you will pay out a referral fee to somebody, or does that need to now be accounted for under only a Fidelity Fund certificate?
In fact, that what you call the referral fee is not
Yes,
even
sir.
allowed.
I'm is not allowed. Okay, so spotters
allowed at
commission,
all.
referral fee is not. So if the
The
admin lady
Act
says she's
says
dealt,
the Act says a property practitioner is entitled to commission as he has done this deal, and at the time when he concluded the deal, he or she had a Fidelity Fund certificate. So whoever comes in and say, I did a referral fee or I'm bringing this client to you, that person is acting as a property practitioner. At the time, does not have an FFC. It's not entitled to commission.
okay, so under the clear understanding, I'm saying that nobody is allowed to bring a referral to an agent because, or they can bring it to you, but we
can
should
bring,
not
but
be
you
paying
don't
them
pay.
any commission.
They don't get paid.
Okay, thank you for that. Thank you.
Thank you very much.
Thank you, Shoni. Let me take your last hand. Please unmute. I give you access to the mic. Shoni.
Good day. Can you guys hear me?
Yes.
All right. Thank you for the opportunity. Yeah, this is just maybe more of a comment / suggestion concerning the FFC and the referrals and the commissions and the spotters fee and whatnot. It makes me ask a question. Who makes the rules? That's the first question. And with that being said, can it be said or suggested that the new rule should be that those people that are spotting or bringing deals should be paid something, or the agency can use their discretion? Thank you.
Mr. Mpiepa, do you want to comment on that?
Yes, the laws are enacted by Parliament, my brother. Ours, as a regulatory body, we enforce the law. So we are enforcing the law. The law is telling me that for a person to any commission, that person must be registered as an estate agent and have been issued with a Fidelity Fund certificate. Anything outside of that, I'll prepare the charges against that person.
Oh, okay. Can I suggest that there be how should I put it? That there be another suggestion to the Parliament to say the manner in which this thing it is not contributing in any way to that one who doesn't have bread, but they do have something that they can do, which is to give a referral or whatsoever. So directly or indirectly, it is job creation. So can we, or can I rather, suggest that you guys go back to Parliament and say, how about this? Thank you.
Okay, I believe during the consultations is when these issues should be raised. You'll note that before the Property Practitioners Act into effect, there were a lot of consultations regarding those things. So then your suggestion will require an amendment to the Act. So in other words, it will mean then it must go back to Parliament and it be discussed there until a decision is made as to whether they will make such an amendment. But for me, in order to properly regulate the body now, I will simply go and enforce the Act as it is, because I'm a creature of statute. Mine is simply to go and make sure that the laws are enforced.
Thank you. Hloni, thank you for that. I think Mr. Mpiepa also knows it. We will discuss with the enforcement executive on that. We were supposed to finish at 12. Let me not disadvantage the last two hands. Can I allow colleagues? I know you are tired. The last 10 minutes before we close. Krista, can you unmute and ask your question?
Hi there, thanks so much. So I have a question regarding a landlord who is currently in breach of his contract. So there's live wires that are out by the pool area and the gate motor is not working, and obviously it's safety issues. Are we allowed to enforce from the agency's side that we have these repairs since he's not communicating or coming back to us? But obviously it puts the tenants at risk.
Ms. Lingau.
Is that meant for me? Because she's speaking about agencies.
She was talking about the tenant who's renting as well when they're doing inspections of things are not, defects in the property.
Correct.
And then, yes.
Okay, so the recourse still remains, ma'am. The tenant is more than able and allowed to approach the rental tribunal, and having stated all those facts that number one, sounds like a health hazard, and all the other elements that are salient to that, they can be ventilated at the tribunal.
Okay, so as an agency, you can't kind of give a time frame for the landlord to respond to you and say you are actioning it if you don't come back to us because of the safety concern.
Look, when a matter is heard in a tribunal, there's usually a time frame that's given to say that after having heard the matter between the two parties, here is a time frame to comply with this. And in the event that you don't, then we move on to enforcing that order. So that's as far as time frames are concerned. I can't give verbatim to say that usually there's like a guideline of saying 5 weeks, 10 weeks, and so forth.
Okay. All right. Thank you.
Thank you. Mosa, please ask your last question. Our speakers have other meetings quickly before we close. Mosa, you can unmute.
Hi, everyone. I have a question here. If, let's say, you have applied for FFC and then you haven't got your results or certificates, then are you not entitled to get your commission? And then another question is that, let's say if a tenant decides to move out without giving you any notice, maybe let's say that they say, I will be moving out on Friday, something like that, are they entitled to get their deposits? Thank you.
The first one, it's fine. I know Mr. Mpiepa answered it. It's on commission. Let me go to Mr. Lingau on the deposit and tenant moving out.
Mrs. Lingau, Naledi.
Mrs. Lingau, I beg your pardon.
You are tired, it's after 12. So I was asking if the landlord can then retain the deposit because the person has moved out without having informed them timeously. Correct?
Yes, correct.
Okay, okay.
So
thank you.
giving a short notice that I'm moving out, maybe in 2 days to come or 5 days to come, without giving the full notice of the month.
All right. So it remains not correct for a landlord to retain the deposit either than for the reasons that are stipulated for in the agreement. So you can't retain the deposit because the person has moved out within a short space of time.
Okay.
Thank you so much for those questions, and thank you to our speakers. Maybe before we close, Mr. Mpiepa, do you have any comments before we close the webinar?
No, thank you very much, Naledi, and to my colleague and to the participants for your time in coming to the webinar. I think it was a very valuable lesson for me to learn other things from you. Your questions were very much valuable and they are of an educational nature to us. We really appreciate that. Thank you very much.
Thank you. Mrs. Lingau, any comments, takeaways, emphasis?
No, thank you, Naledi, for the opportunity. Thank you, colleagues, for attending. And I hope that from now on, colleagues are much more aware of the existence of the tribunal and where to find the tribunal in their different respective provinces. Thank you.
Thank you for that. Colleagues, thank you for joining. We exceeded with 10 minutes, but I've put my email address on the chat. Please send me all your questions. If you remember, I will still send it to our speakers. Even after the webinar, they will still reply to you. The slides I'm going to share with everyone who attended today. The recorder, it will be shared on Friday morning on our PPRA TV channel. And I think those who attended our webinars, they already know the process of how we're going to do it. Thank you for all the questions. And I've pinned a registration email for all Fidelity Fund Certificate questions and queries. Please use that email to follow up on the FFC. We appreciate your time and the questions and the participation. Thank you, Mrs. Geraldine Lingao. Thank you, Mr. Kwadim Piepa, for this informative presentations. Colleagues, please enjoy your lunch and enjoy the rest of your day. Colleagues, goodbye.
Goodbye. Thank you.